One of the most interesting aspects of emerging AI law and policy is how it relates to broader ethical principles that seem to have attracted widespread agreement, at least among people who study AI ethics. In some ways, we might view this like a founding moment. We might compare this to other founding moments. The American founding, the second founding after the American Civil War, the post-World War II global political and economic order, the start of the Internet era, and the start of the privacy era. The American founding, after the Articles of Confederation proved unworkable, resulted in a set of basic principles about freedom, separation of powers, and checks and balances. The American post-Civil War amendments tried to address the lingering cancer of slavery. The international political and economic order after World War II embedded human rights principles into a United Nations structure meant to prevent future world wars. The Bretton Woods system established in 1944 coordinated global monetary policy, and the 1951 Treaty of Paris and 1957 Treaty of Rome established the political and economic basis for the present European Union established by the Maastricht Treaty in 1993. The post-World War II international order began to fray almost immediately because of the Cold War, the US ending the dollar's convertibility to gold in 1971, the growth of Japan and China as major manufacturing and trading rivals to the US and Europe, and the rise in petroleum consumption and economic power of oil-rich Arab Gulf states and conflict in the Middle East. The fall of Soviet communism in 1991 coincided with the rapid growth of the Internet, which became widely available to the public starting in 1993, the incorporation of intellectual property into the global trade system through the trade-related aspects of Intellectual Property Agreement of 1995, and rapid globalization of raw materials, labor, manufacturing and, to some extent, capital. At the start of the public Internet era, broad statements of Internet policy, such as the World Summit on the Information Society Statement of Principles, began to emerge. WSIS principles and similar documents argued for a broadly accessible international information highway in which anyone anywhere in the world could participate. National policymakers at this time, including in the US, decided to give the Internet a regulatory light touch, as reflected in the US Telecommunications Act of 1996. They believed a network driven primarily by social norms, engineering protocols, and computer code would lead to a new era of global community and cooperation. The 9/11 attacks and the US war on terror, including the surveillance authorities created in its wake, the growth of online advertising, social media and the market concentration among a small number of massive technology companies, and the 2007 global financial crisis, all disclosed cracks in the early Internet's egalitarian foundations. Privacy became a byword, along with antitrust, as the EU took the lead in regulating the Internet. The GDPR became effective in 2018, building on the fair information privacy principles developed in the 1970s and 80s. The COVID pandemic further exposed the fragility of the global economy, while new nationalist movements in Europe, the US, and elsewhere challenged the basic premises of a coordinated global order. In this perhaps post-globalist, or at least post-techno-utopian phase, AI emerges like the early Internet of the 1990s. This feels different than the heady atmosphere of Internet exceptionalism. Even the technologists acknowledge that AI cannot be left to govern itself. At least, this is what most of them say. Whether their reasons are genuinely benign or are designed to capture the regulatory process for themselves. The broad statements of AI ethics that have emerged during this new founding incorporate both the kinds of human rights, rule of law principles you would expect to find in classically liberal and post-World War II documents and themes from the modern privacy era. Unlike the early Internet era, there is no suggestion that the governance function should be left to open engineering protocols or informal norms. Notice, for example, that the OECD guidelines, the Asilomar Principles, and the Toronto Declaration all emphasize in their opening sections the importance of proactive human control over AI development. The Asilomar Principles, for example, state that the goal of AI research should be to create not undirected intelligence, but beneficial intelligence, and that humans should choose how and whether to delegate decisions to AI systems to accomplish human-chosen objectives. All of these documents refer to various stakeholders, including states, the international community, NGOs, private companies, and individual users. But there is a particular emphasis in the OECD principles and Toronto Declaration on the role of states in protecting human rights through the rule of law. From these general statements about human rights and human control, all these AI ethics statements emphasize common themes relating to the perceived dangers of AI, including bias, discrimination, and fairness, privacy and surveillance, transparency and explainability, security and safety, accountability, and inclusiveness and sustainability. Bias, discrimination, and fairness concerns arise because AI systems are used to make important decisions about people's lives. AI is routinely used, for example, to screen job applicants, make credit determinations, inform policy research, examine medical records, deliver user-tailored content, influence judicial proceedings, and much, much more. The promise of AI is that it could make such decisions more quickly and with more robust information than human decision-makers, without any emotional bias. The problem is that any AI systems is only as good as its training and algorithms. It is easy to build intentional biases into AI systems, but it is just as easy for well-intentioned systems designed to go awry. Some current large language models, LLMs, such as ChatGPT, for example, were initially trained on basically the entire corpus of the public internet, hardly a source of pure, objective, genteel truth. It's not surprising that such systems will produce results that offend principles of equality relating to race, gender, or other classes where human society continues to struggle with systemic biases. The bias, discrimination, and fairness problem is compounded with AI because people might assume that the machine is always accurate and objective, when that might not be the case. Privacy and surveillance concerns result both from the scale of information needed to train AI systems and from the uses for which AI systems can be employed. Let's say, for example, that you want to train a facial recognition algorithm. You will need a large database of images of human faces for training. Where will you get that data? Some facial recognition systems have been trained on photos posted by users to the photo storage and sharing site Flickr under a Creative Commons license. A Creative Commons license allows copyrighted materials to be reused in other works, usually with attribution to the author. Posting a snapshot to Flickr under a Creative Commons license obviously involves some willingness to expose the photo to the public. But many users posted family photos and the like a decade or more ago, long before training for AI models was on the average user's horizon. Did the Flickr user really anticipate that her family photos would be used to train facial recognition software owned by IBM or some other tech company? Probably not. And what about the use of such facial recognition systems? You are probably at least vaguely aware that the public areas in most towns and cities and the private premises of most schools and businesses are subject to video surveillance. If that video surveillance is connected with facial recognition, the user, whether the government or a private enterprise, can know your specific identity both retrospectively and in real time. If such systems in different places are linked together, the resulting data could track your every move. This is just one subset of privacy and surveillance issues relating to one specific AI-enabled technology. Transparency and explainability questions arise from the black box problem with AI. With a sophisticated neural network or other AI system trained on a large corpus of data and adjusting with experience, it can be hard, and perhaps impossible, to know why a specific decision was reached in a specific case. And when AI systems mimic human capabilities, such as with AI chatbots or text or image generators, it can be hard for a user to know whether a decision or piece of work product was produced by a human or a machine. Transparency and explainability, however, are bedrocks of the rule of law and of free markets. Judicial trials, for example, are generally open to the public, and although juries and judges may deliberate in private, their decisions must be announced publicly and either connected to public legal statements, such as jury instructions, or provided with reasoned explanations. such as judicial opinions. A hallmark of totalitarian and fascist regimes is an opaque decision-making process through which a tyrant can exercise arbitrary power. Somewhat analogously, private markets only function effectively when buyers and sellers possess accurate information about the quality and price of the product or service for sale, the quality and price of competing offerings, and the reliability of the other party. Security and safety are important because the functioning of an AI system can result in personal injury, property damage, or exposure of sensitive private information. One rapidly developing use of machine vision and other machine learning techniques, for example, is in self-driving or semi-self-driving cars. Another is in AI embedded in medical devices implanted in the body. There have already been cases in which allegedly faulty AI systems in such contexts have resulted in injury or death. There have also been examples in which LLMs have been coaxed to reveal personal information through prompt engineering, and cybersecurity experts are concerned about old-school hacking of training databases. Accountability follows from all the other domains. If a medical device with an embedded AI malfunctions, for example, who should be responsible? Traditional product liability rules would include every actor in the distribution chain, but it is unclear whether those rules can or should adapt to the complexity of a typical AI technology stack. Or what about an LLM deployed by a user to deceive its customers? Is the proprietor of the LLM model liable, or only the user? Finally, the domains of inclusiveness and sustainability raise big distributive justice concerns. In the early days of the Internet, the WSIS principle referred to the global information society and advocated infrastructure and knowledge capacity building in developing countries. Today we can still speak of a digital divide between people who have the reliable broadband internet required to participate in the information society and those who do not. We are also beginning to speak of an AI divide, which, not surprisingly, reflects the same long-standing divisions based on wealth. AI is also raising a new set of problems because of the enormous energy demands of the computing facilities needed to train and run large-scale AI systems. Policymakers are concerned about AI's contribution to carbon emissions that fuel global warming, even as some AI applications might help drive innovation in sustainable energy technologies. The domains of inclusiveness and sustainability also relate to the future horizons of AI, both in the short and long terms. Every transformative technology in human history, stone tools, metalworking, shipbuilding, gunpowder, mechanization, flight, atomic energy, rockets, chemical and biological science, computing, has been weaponized. AI is already embedded into weapons such as drones, and its role in armed conflict and national security will only increase rapidly in coming years. Over a longer term, scientists and philosophers debate whether artificial general intelligence, AI with capacities for general reasoning indistinguishable or superior to humans, and perhaps even with moral capacities and sentience, is possible. Most agree that we presently are a long way from AGI, but if it is someday possible, if that singularity is reached, no one can predict the impact on humanity. It may produce a new golden age, or Armageddon, or something in between. Or it may in fact prove an impossible threshold for a mere machine to cross, but thinking and planning now is wise. Obviously, the set of policy and legal concerns raised by AI is enormous. Probably no single framework can address all of them in any satisfying way. The challenge, as it was and remains for all the founding moments in history, is to find a mix of old principles and new models that might carry forward a commitment to peace and human flourishing in a changing and often chaotic and dangerous world.